Good afternoon to all those present here at this public hearing of the Vetting Commission established under the law number 65 on the external evaluation of judges and candidates for the position of judge of the Supreme Court of Justice. I am Andrei Vivol. I am the chair of the panel A of the Commission, and I declare this session open. This hearing is taking place on the basis of the law number 252 on the external evaluation of judges and prosecutors, and on the basis of the regulation of operation and organization of the Commission. The subject of this hearing is Igor Chiroșca, judge at the Chișinău Court of Appeal, which used to be called the Chișinău Court of Appeal. And now it is the Central Court of Appeal. Welcome, Mr. Chiroșca. Good to be here. As mentioned in the notice of hearing on the 6th of May 2025, the Superior Council of Magistracy has rejected the initial evaluation report with regards to you that the Commission issued with regards to you, and it ordered the Commission to resume the evaluation after the completion of the re-evaluation in line with Article 20 of the Law 252/2023. The Commission invited you to participate in today's hearing. With me here in this hearing, there are two other members of the panel. To my left, Madam Lavly Perling, international member of the Commission, and to my right, Lilian Enciu, national member of the Commission. The panel is also assisted by members of the Secretariat. Behind you, there are representatives of the media, the public, and in the meeting right here, there is the photographer who will be taking up a couple of pictures in the initial part of the hearing. The hearing is there is English-Romanian simultaneous interpretation available for this hearing. Therefore, everyone is kindly asked, including the chair of the panel, to speak clearly and slowly, and to make sure that everybody takes turns so that the interpreters can ensure accurate interpretation. The hearing is audio and video recorded. The recordings are to be made available on the official website of the Commission, www.vettingmd.eu, within 3 days after the hearing. During the hearing, a member or more members of the panel will be asking you questions, so please answer with honesty and fully to the questions. Your explanations are important for the panel to assess your financial and ethical integrity. At the end of the hearing, you'll be able to take the floor to have a short discourse. And we will pay attention to the privacy of yours and of your close family members and close persons, so we will not necessarily mention ID numbers, bank account numbers, addresses of real estate, and other alike. To protect your privacy, please follow the same spirit. The evaluation procedure now. This is a hearing in the context of the re-evaluation, so I will make a brief review of the evaluation of Mr. Chiroșca. The Commission initiated the evaluation on the 11th of April 2024 by notifying Judge Chiroșca by email and by asking him to fill out and send back to the Commission an ethics questionnaire, the declarations provided for in the Law 252. Mr. Chiroșca has sent back to the Commission the filled out questionnaire and declarations on the 30th of April 2024. From the 14th of October 2024 through 22nd of December 2024, the Commission asked Judge Chiroșca to provide additional information to shed light on certain aspects in 3 rounds of questions. On the 18th of April 2025, the Commission adopted the evaluation report recommending that Judge Chiroșca pass the evaluation. On the 6th of May 2025, the Superior Council of Magistracy, by decision number 216/18, rejected the evaluation report and ordered the Commission to resume the evaluation of Mr. Chiroșca. Between 26th of June 2025 and the 7th of October 2025, the Commission has asked Judge Chiroșca to provide additional information to clarify certain aspects in 2 rounds of questions. On the 24th of October 2025, the Commission informed Judge Chiroșca about its doubts and invited him to participate in today's hearing. Mr. Chiroșca, is there any corrections or additions you'd like to make to the answers that you've provided so far? Nothing for me to add or amend. Before we ask the questions, we have to address a request that you have filed, an application you filed this night, one that was seeking to have the hearing, closed hearing. In your closed hearing application, your request, you have acknowledged that the deadline for filing such a request has lapsed out, has passed. And to that request, you did not provide, you did not annex any documentation that would justify said delay. But having analyzed the substance of your request, the Commission understands that you want to make reference to the obligation of collegiality that judges have in relation to other judges who are either retired or in office, and to, so to speak, find an optimal solution, we suggest the following. Without any delays or appeal procedures. So the solution that we see out of the practice of the Commission is that you, well, every time you want to make reference to some precedent, instead of using the full name of the subject, you can just specify the initials of the name of that person or subject. So once the questions will have been asked, we will close the meeting and we will give you the possibility to make statements in a closed setting. Will allow you to say everything you believe should be said in camera. Do you agree? Yes. Next, the Commission will ask questions on the basis of the doubts that have been identified as such. Chairman, if I may, well, I have some records that I would like to make available to you. One of them, I would like to speak about it now, and the other one later. And with your permission, I would like to respectfully ask you to allow me to express my position regarding the doubts that were raised. Nothing more than that. It's just that there are certain issues that I could address from the very beginning without even having to maybe dive into the doubts that could otherwise be discussed. And I think this might help us cast away the doubts completely, the questions completely. There is an issue of material nature related to those doubts that I would like to address right now before we even get down to it. We suggest the following. In addition to the closed session, you also have the possibility for some final remarks, by the way. But still, there is that a typo or technical error that I would like to address. Well, maybe then I can suggest the following. When questions are asked, if there is an error in the question, that's when you can make the rectifications. What about annexing the records? I would like you to at least tell us in words a description of what those records are about. So these are two rulings that have to do with my initial evaluation, and the Commission has set this out in the initial evaluation report. It has to do with the second attorney. I have stated that there have been three cases in which the second attorney participated, where I have recused myself. And the examination in those three cases has happened while the legal assistance contract was valid. What were the initials of the attorney? VJ. It's easier for me to say the first attorney, the second one, the third one, but this one, okay, is VJ. The Superior Council of Magistracy, when the SCM thus looked into the report of the Commission and rejected it, the SCM has stated among the reasons, and it has in fact established that two of the three recusals I've filed, that they were not relevant for the case. The same I did. I did the same, in fact, for the first round of questions. I've only submitted my statements of recusal but I did not present the rulings whereby they were accepted. It was not possible for me to show the rulings that admitted, that allowed for my recusal applications, because they were distributed to other judges once the applications were allowed, and thus, through that integrated file management program, well, because of that, I had no longer access to those cases to be able to retrieve and show you the rulings. Now, thinking of the doubts that were raised, I have noticed that at the re-evaluation stage, the Commission noted that I did not take any action, underscored my inaction. So I have further undertaken some actions internally, and I've obtained those 2 rulings that approved my requests for recusal. You can share that with the Secretariat, and we will have a look at them and analyze them after this hearing. But before questions, I would like us to clarify 2 other matters. Is there any corrections or additions you'd like to make with regards to the answers you've already provided to the request of the Commission? No. Now, your answers in the ethics questionnaire and in the declarations that you filled out and sent on the 30th of April 2024, are they still accurate as of today? They certainly are. So let's move on to the questions then. So, as part of the re-evaluation, of this resumed evaluation, we looked into 36 cases from the point of view of conflict of interest. Now, these cases were distributed to you, examined by you. There were 3 attorneys concerned, and in different points of time, you've had some legal aid contracts. Out of the 36, you've sought recusal in 3 cases that you have examined as a non-rapporteur judge at the Center Court of Appeal. 1 of the recusal applications was rejected, 2 were allowed. According to the Center Court of Appeal letter of 8 October 2025, 5 cases are being looked at by other panels than the ones that you are part of currently. So in total, you examined 29 cases in which the former attorneys were involved. In the answers to the Commission, you stated that you have informed the parties in a case where you were a judge at the Strășeni Court. And now, with regards to the doubts that were raised in the notification, in the first round of questions as part of the re-evaluation, you've stated that I believe it is sufficient that by the fact that in the first case, Voloșciuc Petru, represented by attorney S.R., item 1 in the annex to the notification. So I have made the parties aware of my relationship with attorneys S.R. And then when we had the meeting of the judges, this matter was discussed. And to the local community of lawyers, this issue was made known, as well as the solutions agreed upon, they were also made known. It was sufficient that I, as a judge, would ensure the objective, transparent nature of the proceedings, that for an independent observer would not give rise to any doubts about the my impartiality in the examination of the cases in the period of time that the contract of legal assistance was valid. Now, what about the parties to the proceedings? The parties there in the other cases that you have examined afterwards. In one case, you have recused yourself and you've informed the parties. But in the other cases, did you inform the parties about this attorney-client relationship? I will begin with the idea that before concluding the legal aid contract or the legal assistance contract with the attorney S.R. on the 10th of September 2014, since the month of May, there was a pending case with this lawyer, with this attorney. That was about the revisiting a civil decision in a civil case. And that was a pending case. After the contract was concluded, I have, this has become known to me, because even from the first rounds of questions in the initial evaluation, even at that time already, I never negated that I informed the participants in the proceedings about the matter. It's only I did not remember well. My former clerk reminded me of it. And at the next meeting, after the conclusion of the legal assistance contract, I have declared this publicly. I've announced the participants in the proceedings about it. It's only that out of reasons that cannot be imputed to me, this was not written in the minutes of the court hearing. However, this was confirmed by my clerk, by the statement that she made, and that is among the materials of the case. And I would also like to let you in on the detail that the obligation of the judge to include in the minutes of the court hearing the remark that de minimis note regarding a potential conflict of interest. So, as an ethical obligation, this emerged as such, well, at least it was enshrined, so to speak, in an internal regulatory document only as late as in May 2018, when the comments to the Ethics Code of Judges was approved by decision of the Superior Council of Magistracy. That's the course of events. At that time, I had reported the conflict of interest. I have declared it. I do not remember what the case was, though I am sure, well, not that sure because I can't remember, but perhaps, probably in a next case that was examined next by me, I could have declared this as well. However, in the meantime, there's been that discussion internally with the other judges, and I had not applied that practice again. Now, with regards to why I did not recuse myself in the other cases, in fact, there were 5 cases in which the attorney Radu Sergiu participated. Out of the practice of the Commission, but also out of my own experience, it is important for judges, when they recuse themselves, or at least when we think of reporting, that one applies for that, when one moves for self-recusal. It is important for the judge to do that in the initial stages. This case was addressed by the Commission with regards to AM, the case of AM, and there were 2 cases of potential conflict of interest, where the judge has recused or applied for a recusal that was rejected, and then the judge believed it was more important to give precedence to the obligation of the judge to examine the case that prevailed in the judge's opinion, rather than get in the way of the examination of the case within a reasonable time period. And one did not apply for recusal again. And this was a case of passing. But can you please repeat? Can you please repeat the initials? AM. In writing, I made due reference in my explanations. There was another case of failure that had to do with a different colleague, a judge. In the first 3 cases, in the case GM, so in the first cases, no self-recusal was applied for, and in the 4th case, the judge applied for self-recusal, and this action of the subject of the evaluation was interpreted that if for the 4th case the judge admits to have been in a condition of incompatibility, then this gives rise to the question as to whether he was in that similar position in the 3 other previous cases. But there is a practice, which is a natural one, that since you once filed or twice, when you submitted this notice of self-recusal once or twice and it was rejected, then in the next cases, the focus is on the benefit of an established fact, or a certain matter that has the value of a practice within the court. I understand that for you and for the judges in the court, this is known and it is sort of self-explanatory, but from the point of view of the participants in proceedings, it's about their right who have not been informed about the existence of a relationship between you and other participants in the proceedings. So this is where the question is coming from. How is their right secured? How is their right to know guaranteed, as well as their right to file a motion or a request of recusal, given that if they knew that there was a relationship between the judge and the attorneys that could cast some doubt onto impartiality? Thank you for the question. My answer is the following. I believe that I have supplied enough evidence to the Commission. And as for the resumed evaluation, I informed the Commission. I made it known to the Commission. There's been written statements confirmed by all of those attorneys who, from 2014 to 2017, were working in the district of Strășeni. And these declarations confirm the fact that these circumstances, this condition of conflict, potential conflict, this was made known to the entire community of lawyers in the district of Strășeni. Now, these lawyers have all confirmed that they never had grounds for recusal. They never moved for that, and there were all the judges who were in office at that time, who were working at that time. And in a way, at that weekly meeting of the judges, it was agreed that through the secretary of the court, the decision was made to inform the entire community of law professionals, including prosecutors, to inform them about the practice in cases like this, of this type. As regards the parties to the cases, if we think of the circumstances that there were only 5 cases in which the attorney SR participated during the validity of that contract. And if we think of the value of the litigation, if we think of the impact of the decisions for the parties, and if we think of the fact that those decisions have not been challenged, and the parties to the case accepted them, and thinking of the fact that those parties were to a great deal assisted by the attorneys from the operating in the radius of the Strășeni court, so to speak, and there were no complaints. No complaints with regards to... Well, nobody complained about how I performed as a judge. And for this reason, I believe that even if I had the obligation in a way, and I admitted to this from the very beginning, I had the obligation to, well, if not recuse myself, but to at least inform the parties about the matter. Still, it is what it is. I do not claim that I was right. However, as stated in my answers to the questions, knowing the state of affairs internally in the Strășeni court, knowing that I had the obligation to bring to a minimum level, to diminish, according to the Bangalore principles, when a judge believes that they are in a potential conflict of interest, they are to diminish to a minimum level the chances that, or the possibility that the impartiality situation, so to speak. I tried to be as diligent as possible. I doubt that the parties were not aware of it, or at least the attorneys representing those parties, they too were supposed to be diligent and tell them that, look, there might be potentially a conflict, but did they do that or did they not do it? I cannot comment as to that, or at least out of the other actions after my decisions have been communicated, and considering the impact onto the rights of the parties who were not on the winning side, I did not observe or notice any doubts about my impartiality.
Let's then discuss about something more punctual, more specific. In your responses in the rounds of questions, as well as within the initial hearing, you stated that every time when in a hearing the attorney VG was present physically, you recused. And I want to make sure that we understand correctly. In your opinion, the obligation of the self-recusal obligation is to be executed only when there is the physical presence of the party in the trial. So this obligation is determined by the lack or presence of the party in the trial, or rather whether formally the lawyer signed or there is a mandate in the case file. This obligation appears regardless of the presence of the lawyer in the hearing or not. With regards to the second attorney VG, I affirmed this because of the following reason. There have been 3 cases where I self-recused or asked for self-recusal, and these are the only 3 cases which were in the proceeding of the panel where I was part of, and where the attorney VG participated effectively physically in the hearings. I can't say in which of them I was a rapporteur and which ones I haven't been a rapporteur, but out of these 3 cases, relying on the principle according to which or hypothetically, if in one of the cases where I self-recused or asked for self-recusal, the rapporteur was a different judge. Or we could also admit a different situation where VG attorney hasn't participated in front of me in a hearing, but at earlier stages, such as criminal investigation stage or in other proceeding cycles after a re-examination, if there was any mandate of that attorney, I physically wouldn't have the possibility to be aware of that if I wasn't a rapporteur. In other words, you allowed me to make the remarks in the meantime. I'd like to ask a clarification question here, because oftentimes we get into this subject of rapporteur versus non-rapporteur. We received a letter from the Court of Appeal Chișinău regarding the practice of the criminal panel of the Central Court of Appeal, according to which reporting judges are not obliged to report to the panel the identity of the people identified or to present all the materials administered during the criminal proceeding. Should we understand that ensuring a fair trial by declaring a recusal to avoid conflict of interest is attributed only to the reporting judge? So practically all the other judges in the panel do not have access to the case file? I will respond to this. So my response is as follows. Including in point 74 of the doubts raised by the Commission in this notification, The Commission, similarly to your question, sets out the following, that regarding the cases in which the subject wasn't a reporting judge, the members of a panel have the same responsibility with regards to ensuring the impartiality. Even if he's not reporting, the judge has the obligation not to allow for any potential conflicts of interest, and the lack of some regulations internally does not exonerate the judge from ethical obligations. My response to your question is as follows. I perfectly agree with you, but as long as there is not even one methodology or a decision of the Superior Council of Magistracy which would stipulate for a way of cooperation internally within a panel or a methodology for the staff assisting the judges, where they would be obliged to check for additionally in the cases, to make verifications, and to identify the people participating in the earlier proceedings, as long as there is no written obligation enshrined in any legal documents to communicate to the members of the panel about all the state conditions of incompatibility, the non-reporting judge to find out what's in the case file of the reporting judge. We can't speak about a legal presumption that the non-reporting judge could be aware or is obliged to know, to be aware of what's contained in the case file of the reporting judge. I have a line of thoughts, and I would like to, but I have a clarification question in order to have a constructive discussion. So you justified until now what's not existing, but could you please tell me what's existing? How it's happening? How do you examine if there is any uniformity in the panels of the criminal panel which you are part of, and how are these case files examined within the panel? So the case file is in the hands of the reporting judge, and he is just holding it and not providing access to the other colleagues. And I'm asking myself how the other judges could sign together a decision in a case where they have not access to. Based on what? Based on just the statements in the court? So it appears bizarre, but the relationship in a panel of 3 judges, and I guess in the relationships between, among the members of this panel in front of me, is based on mutual relationship, mutual confidence. And the only rule which stipulates that the difference between a reporting judge and a non-reporting judge is represented by the regulation on the establishment of the panels, trial panels, which defines what means a reporting judge. The reporting judge is the person who is obliged to draft and present a report on the observance of the formal conditions and the reasons on which the pretensions, the claims rely. No other obligations exist in relationship to the reporting judge. That's why every panel acts as they think is okay to draft and to present a report and to adopt a decision. But it is true that in the case of a behavior which deviates from the main rule of confidence, there is a risk. And I could give you a simple example that I went through. It happened twice, where a relative of mine of second level, who is also a lawyer, and I always recused in his situation. There were cases where this relative of mine, he represents the interest of some well-known brands in Moldova, commercial brands, and I identified my incompatibility only based on the nature of the administrative offense committed. And the reporting judge started to report on the case. He started to mention about the objects of the misdemeanor, and only upon my question, please could you tell me what are the objects? And he said these are clothing items. And the second question is, what brands are involved there? And only after that, I was capable to understand that actually, knowing that my relative is the only person representing the interest, I took the case file and identified the power of attorney where that attorney was included. So things are not well drafted. So I'll try again. And please respond with yes or no. Non-reporting judges from the panel, do they have access to the case file or not? They do have access to the case file. But in the conditions where 3 judges go into deliberation to deliberate on 20 cases each, in total we have 60 cases. I don't want to complain on the overload caseload, but indeed we do have 60 cases. And our legal obligation is to provide a fair solution, and we do not do any verification of the cases of each other. We rely on mutual trust because we have a constitutional mandate and we need to rely on the law. So it results from your statement that a case file basically is examined, analyzed only by the reporting judge and his assistants, not even the assistant. If I speak about myself, I personally don't rely on the report from the assistant. The examining or studying of the case file is my own responsibility. But what other judges do, I don't know. I can't answer for them. But this is the clarification because I wanted to provide some records. I anticipated your question. But before attaching, I would like to mention a fragment from the decision of the Constitutional Court number 2 of January 16, 2025. Where in paragraph 208, Constitutional Court maintains, regarding the fact that the subject evaluated could be dismissed from his office because he didn't recuse from the examination of a case, although there were circumstances questioning his impartiality, the court retains that it is important to establish the fact that the subject to evaluation was aware about the circumstance discussed and didn't recuse. So, again, I will repeat what I said earlier, that as long as there is no deontological rule or methodology at internal level, and the inexistence of that is presented by the document issued by the Central Court of Appeal, there couldn't be a legal presumption that the non-reporting judge doesn't intentionally doesn't recuse. So, but don't you believe that if a decision is signed by 3 judges who have the same level of responsibility, the position of the rapporteur is more administrative. It's not well, the reporting judge doesn't have a stronger vote than the other 2 judges. Non-reporting judges could also take a decision, and the rapporteur could have a dissenting opinion. Don't you believe that there is a presumption based on the principles of legal lawfulness, professionalism, and general expectation from the parties that if they are in front of 3 judges, all 3 judges are aware, know their case file at the same extent? Well, the presumption that all judges are aware of the case file exists. And this presumption operates on the solution provided on the merits of the case. And this presumption operates based on the report on the circumstances of the case which the reporting judge is obliged to present. This presumption doesn't operate ex leges for incompatibilities or for potential conflicts of interest. Given the fact that for the third or fourth time tried to attach some records, we will attach all of them. We accept all of them. So I would like to mention what's written in here. So we have 1, 2, 3, 4, 5, 6, 7, 8. There are 8 lists from 8 different judges who are now in office. This is public information. Well, not public information, but it provides free access internally for judges to facilitate communication within the team. And it indicates the lists with the cases with which we used to go for reporting. It's not a novelty that since 2022, given the modernization of the criminal proceedings, many of the cases moved from public proceedings in written procedure. I've written what are the reporting judges and what's their manner of presenting information on the cases which they report on. Some judges indicate the name of the offender, the author of the claim, and of the appeal, and who are the people involved at the stage of the appeal on points of law. Some others indicate who the appeal on points of law belong to without indicating the matter to be settled. And this stems from the report of the reporting judge. And other judges do not indicate even the people involved in the proceeding, only they only indicate a written procedure. This represents, I guess time hasn't come yet where the judicial system or the methodology for deliberation on the cases in a written procedure to be regulated in a more thorough way. But these records I ask to attach includes the lists, and sometimes in this list there are 30, 40 cases pending before one judge. And I will reiterate my position expressed within the round of questions earlier in the previous stage, because this question was raised in the initial evaluation stage, where I mentioned that there are some categories of cases, and I apologize for this expression, but they are like belt. So if you see who is the author of the appeal, and then you look in the request from the appeal, and you see that the decision and the appeal on points of law, you see that the solution of the judge is correct, then the judge wouldn't move to examining the merits themselves. Just a simple example. For instance, there is an appeal against a search, and it doesn't matter who the subject is, because sometimes we get investigative judge who have 15 cases with different locations or different domiciles, but we examine all of them together. I'm not looking at who the subject is. So the investigative judge rejects the request of the prosecutor, and when they come to us, we only look at how correct is the justification of the court and how truthful is the counter arguments of the prosecutor. And we are obliged during 24 hours to examine such appeal on points of law. So these are cases which can't be delayed. So we don't have time to go into the core of all the essence of all the cases. And the matter sometimes determines the solution without allowing you to Could you clarify if in any of the cases notified by the Commission in the notification about the hearing, in the list of doubts, if any of the 21 cases was of this type which you were mentioning, which are urgent, which where the judges have to give a quick decision and where the timelines are very short and there is no possibility to check on all the circumstances. Is there any such case here? I haven't examined on matters in apparently there are no such cases.
Dar eu m-am axat pe cauzele așa cum s-a axat comisia.
But I focused on the cases as the Commission focused in the first round of the cases that I had on the procedure as a reporting judge. And I am trying not to rely on this rule, but I admit that in some cases it might happen that I wouldn't study them, but I draw more attention to the cases nominatively, and I expressed my opinion in the earlier procedures in my initial evaluation. The cases that you mentioned post factum in the re-evaluation, as it was mentioned in the question, they concerned only the cases where I wasn't a reporting judge. So I didn't draw much attention. I prepared on some of the cases which were more substantial, that I didn't get into their core of them because I think since there are no obligations to recuse from cases I am not aware of. So let's speak about the contractual relationship. As it was established in the initial evaluation, the agreements for legal assistance with two of the three attorneys were concluded on your behalf through some people authorized by power of attorney. In the CSM decision, it is affirmed that even these agreements were concluded by the authorized persons, they produced effects before their formal execution. And CSM also mentioned that the objective test of the impartiality reclaims the same level of precaution regardless of the way in which the conclusion of the contracts was delegated. Even if you delegated other people through power of attorney to sign agreements for legal assistance, in the end you were the beneficiary of those services. So our question is, if you consider that delegating the conclusion of agreements represents a fact which mitigates or eliminates the doubt of an independent observer regarding the potential conflict of interest. So my response to this is the following. Actually, when the Commission drafted my evaluation report on the 18th of March 2025, the Commission listed 7 major differences between my case and the case of other judges. Unfortunately, the Superior Council of Magistracy, out of the 7 differences, retained only one, and specifically the fact that the minimum requirement wasn't ensured. I apologize. So the fact that compared to other judges, I have different subjects of evaluation. I concluded an agreement through power of attorney to delegated people. In the first round of evaluation, first round of questions, I identified actually outside the 7 ones that you established in the first report, 11 major differences, aside from the fact that I concluded the agreement through an proxy, through an intermediary. At the same time, in the same round of questions, I identified 7 or 6 similarities with other cases where there were situations similar to mine.
If you allow me to sum it up, the mere fact that the contract was entered into via a representative that was regarded in isolation. We take that in isolation, that cannot be treated as a circumstance that exonerates me from accountability. But the accumulation of these mitigating circumstances, they were referred to in the report and prompted the solution of the Commission for the first report, and I'm trying to make a case for that now. What is more, I tried to prove that it's not only the fact that it was entered into through an intermediate. And you know what I said in the initial hearing, the previous public hearing, you have raised the question in the following way, as in, don't you think that by entering into the contract of legal assistance through intermediaries, don't you think that that will look like an attempt to hide away, to hide the fact that you had, that you wanted to not make it known that you had a relationship with the attorney? And my answer was that it wasn't, that it was my attempt to diminish maximally my interaction with those attorneys. What is more, I think I've proven at the time of the initial evaluation, I believe I managed to prove that there were no grounds and no reasons for me to meet with those attorneys. In the first case, where RS represented me, the case had been initiated in 2011. I have written down the lawsuit as and the position that I had, but he participated then at a later point, and because I was a judge, I did not want to appear in front of other colleagues of mine, judges in other courts. So I believed that I could be provided the services of an attorney in reasonable conditions for payment, of course. In the second case, his task was only to take over my arguments in my application for a lawsuit and to just perform their duties as attorneys. And then I've explained that with the second attorney, he was in fact representing my wife. And for reasons of procedure, the case was, that lawsuit was rejected all the way to the Supreme Court of Justice for reasons of procedure, related to procedure. And my wife also has higher education, given that the litigation was around the apartment that we own together. That attorney, VJ, has taken over the same reasoning, went to court instead of me having been empowered to do so by me, but through my wife, and he pleaded as he could just pleaded for further interest of my wife. I did not have, I say that I keep supporting that I engaged in no communication with those attorneys, not during, not before, not after the examination of the case. It is in this particular way that I've made sure that I acted properly, correctly, in line with the principles, the Bangalore principles. Judge Chiroșca, in the three cases where VJ was the attorney, the cases were mentioned in 18, 19 and 31 in those items. So you've stated that you've had a discussion with your panel colleagues regarding the possibility to self-disqualify, to recuse yourself. But then you've stated that a statement like that that there were little grounds or reasons for the recusal, and you've explained why you did not recuse yourself. And this makes me think of two questions. On the basis of Article 1, Paragraph 4 of the law on the status of judges, the judges make decisions independently. So every judge is to decide for him herself. Don't you believe that your decision, the decision that you take, having consulted with your colleagues, with the colleagues of the panel, don't you think that that could raise doubts as to your impartiality and as to your independence? Because it might have been perhaps easier, simpler to inform the parties about those circumstances, and the parties would have decided if maybe a recusal should be applied for. Maybe the parties would have decided that indeed there is no reason to
doubt your impartiality, and that most likely could have been the case, the scenario, but there is no way for us to verify that and to know that. So this way of decision-making on the basis of consultations with your colleagues. Now, in your view, doesn't this affect the independence and impartiality of a judge? My answer is the following, and I will reiterate that I have anticipated this question because I disagreed with item 75 of the doubts that were communicated to me in the notice. There, the Commission, given the question that was raised, the Commission has mentioned that the ethical obligations are personal and can be derived out of the Code of Ethics, not out of the internal rules of a court. The ethical responsibility is individual, not collective, and this is why the decision of the subject to rely on counseling or advice sought from the colleagues cannot be supported. I agree with you, but that is just a conclusion that you have arrived at erroneously, because in the declarations or the statements that were made, there are actually 3 cases, two statements for each from my colleagues. In those statements, my colleagues stated that I had informed them that in those proceedings there was the attorney VJ who was involved, with whom I have had a contract-based relationship in the past. I have the 3 cases and the names. The first one, Marius Marian. It had been about 3 years. Then Ekaterina, 2 years after the contract finished. And the other one, the third one, I think I've examined it about finishing the examination about 2 weeks ago. I have made that known, but all the judges stated, and I will read out from their statements. However, they need to declare or not recusal on the basis of the case that is left with a judge. I did not confer with my colleagues to ask for permission to recuse myself. I have exercised my obligation to let them know, to communicate that. I was acting on the basis of the principle of trust, though they were aware because they participated in the examination of my previous notices of self-recusal, which I've asked for them to be annexed today as well. So they were in the know, they had knowledge of the fact that that attorney had represented my interests. I have just reminded them. We have had another discussion. I mean, the internal practice is that, as a rule, there aren't reasons for recusal because the conflict of interest exists for the entire period of validity of the contract. But then it was up to me. So all judges have mentioned this, so it was about my diligence and my decision. And I would like to add that I am aware that examining the case of 2025 or 2024 after in 2022 February, that's when the contract has finalized, and I did not file any notice of recusal. I think that I would have hurt myself even more if in 2025 October, if I told the parties about it now. So I think that is a clear matter. I don't want to go into discussions about the case you are speaking about. I think that the differences are really big when it comes to those 2 cases, so I don't think we can see them as analogical. In the initial evaluation and in the resumed evaluation, you submitted to us 3 notices of self-recusal. They had to do with attorney VJ. 21, 22, 23 are the items in the annex to the notice where this is addressed. And you provided a copy of a ruling whereby one of those notices was rejected because you did not annex to that the copy of legal assistance and the copy of the mandate of the attorney. So you hadn't annexed that. What we are interested in is what is the reason why you did not annex those to your self-recusal. I did not
do it for the other two rulings either, Chairman. Now, I have the for those two rulings that I want to show you for you to have a look at. Now, I can't comment as to why those judges rejected my notice of self-recusal, because there was not a legal ground for that. There's an article that states that the panel who examines the motion of self-recusal can seek explanations from the judge, but I was not asked for explanations. They did not seek explanations from me. So that is the risk of inconsistent practices inside a court, and there has to be consistency. Haven't you anticipated that you'd have to argue, that you'd have to provide evidence that shows that you had a relationship? The Criminal Code in Article 352 prime, it provides sanctions for when one makes some statements that are not truthful. Well, this has no link with the hearing. This is not linked to the hearing. Now, do you think that is the article that would have otherwise been applicable to you? Well, I don't know how, in practice, this would be assessed. It was not applicable, certainly. But how could I be, for instance, if I'm a judge, but then I file a self-recusal notice, and if I claim circumstances that are not true? I mean, how could I do that as a judge? That is a much worse violation. And this Article 352 prime that could matter, indeed. Well, it appears that those who rejected it, they might not have believed you, did not take you upon your word, because you did not provide evidence. But then again, I cannot file on the same grounds the same notice of self-recusal. The panel, which is mandatory, the panel was supposed to ask for explanations as per the Code of Criminal Procedure. And that can be easily done in interpersonal relationships or in the hallway. They say, look, you filed that application or that notice. Can you provide the evidence, or to print it out and annex it? So you think the decision of your colleagues to reject your notice of self-recusal was correct? The ruling is not up for discussion. The ruling is to be observed. And if you had annexed the contract and mandate, I'm sure they would have allowed it. But we don't know. You see, there is another matter about recusals, self-recusals in vocational courts and vocational court of appeal, center court of appeal. They're looking into it through the lens of impartiality when it comes to recusals. However, the Commission needs to understand, and I hope that it will understand, that 80% of all of the cases appeals that are looked into in Moldova, 70 or 80% of them, they are all looked at the Center Court of Appeal. These are high-profile cases, and it's very easy to juggle with the grounds for recusals, for rejecting recusals, and so on and so forth. Sometimes, in order to put an end to the actions of some judges who are abusing this, you have to reject some notices. And it is perhaps the case that the colleagues who've looked into my notice of recusal, self-recusal, they must have thought that it is my obligation to apply for recusal, and it's not always that it's going to be, you have the obligation to file for self-recusal, but not obligation to grant it. So they thought along the lines as in, so what if you have a contract-based relationship? It proves, in fact, that at the end of the day there is no unanimity in treating this case, or no consistency in treating this. So it did not come out. It's only now, and just to make a clarification, I have prepared many other things that I wanted to communicate to you. In 2015, actually 2025 now, in May, the Supreme Court of Justice, in its desire to reform case law, to address it, it developed something like a thematic systematic form on request of displacement in misdemeanor and criminal cases. And there is a thing that is important and applicable to my case too. The Supreme Court of Justice has mentioned what application of displacement needs to be granted on grounds that there are, for instance, suspicions of impartiality. So this displacement makes reference to Article 33 that provides for the incompatibility and the interpretations of the SCJ in the context of displacement, but which is also applicable to judges who are to report or who are to address recusals. If now a Court of Appeal, former Court of Appeal judge or a Court of Appeal judge, if they were a party to a case, then they would be displaced. So now there is the case of a politician distributed to the panel that I am part of. We tried to file an application of displacement, to have it moved elsewhere, but it was rejected. But the ground there was that all the witnesses in that case, all of them were colleagues of ours, judges. So there was interference in administering justice. The events had taken place within the courtroom. The person has come and caused chaos given those circumstances, and we did not have the case moved elsewhere because there was impartiality that could be an issue for all the judges, and that had not taken place because the Supreme Court was addressing it like that. So this thematic document that the court developed makes me think of something like that in Court of Appeals. These recusal applications and displacement applications should be reduced as much as possible, because at the Court of Appeal the cases are being looked at by panels of 3 judges, and from the very beginning the suspicion of impartiality reduces the intensity. So these are things that are being said now, and they are valid looking at the case law of the European Court for Human Rights. It's only that they were not actually followed in practice. Now, Mr. Chiroșca, let's follow further down the list of questions. My last question has to do with a rather recent case. In your answers of the 3rd of July 2025, in the first round of questions, you've mentioned with regards to the Coptileț case, represented by VJ, item 19 of Annex to the notice, that because of the workload, you did not look into the materials of the case, and you were not aware who the parties to the proceedings were. On the 30th of October 2025, you've examined and adopted a decision for that case as a judge rapporteur. Could you tell us if you self-recused or if you applied for that, or if you informed the parties about your relationship with attorney VJ, and how was this settled? Now, following the same practice, Chairman, the same practice as applied in other cases, I have submitted the statement to the 2 other judges that I examined the case with. I've informed them. I let them know that that attorney had represented me. The solution was not in favor of the client of that attorney. They participated only in the court that examined it on the merits, so there was a matter related to probation, unpaid community work instead of imprisonment. The attorney got a favorable solution in the court that examined it on the merits, but then we disagreed and we asked for a trial because there were reasons in that regard. So, but then that was a case that, as I've stated, it occurred about 4 years after my relationship with that attorney was terminated. So now, do you, Mr. Chiroșca, do you think we need to have a closed session now? I think not. So I would just like to read out. I put down some messages that I would like to convey if I'm given the floor. We will give you the floor anyway. You have the right to make a statement. My question is that if you'd like us now to close the hearing for you to make the statements you refer to in your request for a closed hearing, if so, then we will have it closed before we give you the floor. Everybody is sitting here, Secretariat. Please leave the room except for the interpreters and the technical staff in charge of the video and audio recording.
Since we are back in public session, Mr. Judge Chiroșca, would you like to make a short statement before the conclusion of this hearing? Mr. Chairman, before the conclusion of this hearing, before the short statement, it will be very short actually, I would like to kindly ask the Commission, although in the doubts retained by the Commission in my regard, in principle the Commission agreed with the new mitigating circumstances which haven't been taken into account. But given the fact that this is a public session, I wouldn't insist, but I would kindly ask you for the permission to express my opinion, because I identified the circumstances after I was sent for evaluation. So in my questions, in the round of questions, in my responses, I brought as justification the circumstance that the following two circumstances. Mitigating the lack of declaration of recusal and to tell the parties about the potential conflict of interest with the judge lawyer assessed needs to be performed with the court where I exercise my office in Strașeni. According to the public sources, Strașeni Rayon has a population of 82,000 people, and the population of Strașeni is 18,000 inhabitants. In this context, I'd like to mention about the material substantial error that I think is a material error in point 72 of the doubts raised by the Commission. The Commission establishes that in the town of Strașeni there are around 82 million people. This in the region is 82. In the town there are probably it was about the region, not about the town. But given the fact that the community of lawyers are in the urban centers, I mentioned the 18,000 inhabitants. We have three cases from the ACHR case law against Liechtenstein from 2010, where the court mentions that the realities of some small countries like Liechtenstein impose that the principle of impartiality of judges would be interpreted in a more permissive way. Particularly in Liechtenstein, judges could practice being attorneys at the same time, so part-time as attorneys. And also AC case against Liechtenstein, where the court mentions that the recusal applications shouldn't paralyze the legal system of the state. And in small jurisdictions, the excessively strict standards about the recusal applications could hinder the administration of justice. Mikalev versus Malta case, 2009. The court says that we couldn't overlook the fact that Malta is a very small country and more members of the same family practice at the same time being attorneys and perform justice. So this is a common phenomenon. In this case, the plaintiff pleaded in front of the ECHR on the impartiality of the judge, who was a brother with the attorney of the other party. The government, therefore, after this case examination, recognized that this was a systemic problem and introduced in the law the obligation for the brothers and for siblings who participate in the execution of justice to recuse. In terms of statistics, the population of Malta in 2014 was around 430,000 people. The judicial system was composed of two levels, lower courts 2, and there were 22 judges. Higher courts were 24. There were 24 judges in higher courts. In Strășeni today, in Strășeni court, in the staff list, there are 14 judges. 8 are in the central office and 6 are in Călăraș office. So these are comparable things, and that's why not taking into account the fact that the territory influences the limits of appreciating the borders, determining the impartiality of the judges should be taken into account. Second argument, and I thank the Commission that you took it into account, although this doesn't exonerate my responsibility, but this is still a mitigating circumstance that can't be overlooked. So the fact that in my case, the authority of the president of the court and the senior judge colleagues undermined my discretionary power and my independence. And I will not mention the names, but you all know that there is another case where the Commission established, based on the ECHR case law, the fact that senior judges sometimes the performance could represent a mitigating circumstance. I would like to say that when I concluded the agreement with the attorney RS, I had only 2 years of experience. The other judges were senior. They had over 10 years of experience in the office. And Parlov Hatic against Croatia case, where the court convicted not the capacity of the state to ensure the independence of judges from the outside, but gave a treatment of the independence of judges from the inside. All the more when we speak about the capacity of the president of the court or the senior judges to influence decisions by the junior judges. There is also the report of the parliamentary reunion for 2015 about the exercise of justice in Moldova. Just 2 minutes. And from the content of that report of the Parliamentary Assembly, for the period of 2015, it is established some inadvertencies, incompatibilities which had to be eliminated, inconsistencies. So the role of the president of the court should be exclusively administrative rather than intrusive. Secondly, any instructions or suggestions from the court presidents or senior judge colleagues or other collective structures such as periodical meetings, whereby some directions are suggested could raise systemic impartiality issues. And I will refer here about another case, A.C. I made reference to my examples in the responses, where the judge admitted that he had an informal discussion with the president of the court, where they agreed as followed, that every time the person who was close to him would appear in front of him in hearing, he should have sent the case to another judge. And in the case of impossibilities to merge the case, he would declare himself, he would recuse himself. And the Commission accepted the argument of that subject, who recognized the influence of the court president in the exercise of justice and in his behavior. No, Commission hasn't accepted. It was about a procedural solution rather than solution on the merits. I'm not referring to your solution. I'm referring to the fact that the judge, when he was subject to evaluation, he diminished from his responsibility to the fact that he had an informal discussion with the court president. The Commission, of course, hasn't gave an appreciation to this, but in the report it is written, and I take it over as the other judge did as a subject of the evaluation. I will mention this, and I would say that that example is a reflection of the fact that in those years, 2015 or 14, are not the same as the Commission perceives now, which was established based on the law from 2023. And the third aspect which the Parliamentary Assembly of the European Commission established for Moldova is that there needs to be limited the mandate of the President of the Court to influence the case assignment and to initiate disciplinary procedures, to influence the career of judges through prior agreements, even in informal agreements, as it used to be before. It was mandatory earlier to go to the evaluation panel to present the characteristical report from the court president, to create the panels of judges depending on the so-called informal leaders of the court, to censor the dissenting opinions to which I was a victim, or creating artificially conditions for professional isolation, which I, as a young professional, couldn't afford doing. So these realities established by the Council of Europe Assembly in 2015 were realities characterizing my condition, my situation as a junior judge in a team where many judges started to be judges during the Soviet times. At least 3 of them were in office at that time. And as a conclusion, I would like to thank you very much for your patience and for the fact that you allowed me to present the arguments as I did. Thank you very much, Mr. Chiroșca. So we are at the end of this hearing. I would like to thank Mr. Chiroșca for the information he presented and the statements made in the hearing today. Following the hearing, the panel will approve an evaluation report where it will mention its conclusion about whether the candidate meets the ethical criteria stipulated in Law 252. The evaluation report will be approved and drafted as soon as possible. I declare this hearing closed.